Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, you was asked to come to court for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what options you have regarding your case. The paperwork that has been handed out, I will go over that paperwork with you. Now, we handle Class A and Class B misdemeanors in County Court at Law Number 2. Your case that you have is a misdemeanor case. Criminal cases are divided into either felonies or misdemeanors. Your felony cases are your more serious type of offenses. They are handled in the district court. And for example, a felony case could be a capital murder, or it could be a first-degree felony, or second-degree felony, third-degree felony, or a state jail felony. With your felony cases, if you are convicted of a capital murder case, your punishment can be anywhere, well, it could be life or death. Or if you're convicted of a first-degree felony, the range of punishment is 5 to 99 years to life, fine up to $10,000. If it's a second-degree felony, your range of punishment is 2 to 20 years, fine up to $10,000. Or if you have a third-degree felony, the range of punishment is 2 to 10 years, fine up to $10,000. And the lowest felony that you can have is what we call a state jail felony. And the range of punishment for a state jail felony is a minimum of 6 months to 2 years in the state jail, fine up to $10,000. We don't handle felony cases in this court. We only handle misdemeanor cases. And the misdemeanor cases that we handle are Class A and Class B misdemeanor. Misdemeanors are divided into Class A, B, and C misdemeanors. Your Class C misdemeanors are fine only. That's the range of punishment. You cannot be given any jail time. And those cases are handled in the city court, or what we call municipal court, or the JP court, which is Justice of Peace Court. However, if the case is appealed from the JP court or the city court, then it will come up to this court, the county court. And if it comes to the county court, the range of punishment is still the same. It's still fine only. We cannot give you jail time as punishment. Now, the cases that we normally handle are Class A and Class B misdemeanors. Your Class A misdemeanor is your highest misdemeanor, and then the Class B is next, and then your Class C is the lowest misdemeanor. For a Class A misdemeanor, the range of punishment is anywhere from 0 days to a maximum of a year, or 365 days in the county jail, a fine up to $4,000, anywhere from $0 to $4,000 or anywhere in between. For a Class B misdemeanor, the range of punishment is 0 days to 180 days, which is 6 months in this county jail, fine from $0 to $2,000, or you could be given both such fine and confinement. Now, so the case that you have in this court is probably a Class A or Class B misdemeanor, unless your case was appealed from city court or the JP court, which is a Class C misdemeanor. Now, the paperwork that you have in your hand is titled Judge's Explanation of Rights to Defendants Without an Attorney. Now, as a defendant in a criminal case, you have 3 options. One, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. So those are the 3 options you have with regards to having an attorney. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. However, if you've already hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. However, if you've already been appointed a court-appointed attorney, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign at the bottom where it says defendant, and you will date it today's date, November 2nd of 2021. Now, for those of you who will be representing yourself, then you will need to read and fill out the second page. The second page is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 2nd day of November of 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line where it says defendant, and you will date it today's date, November 2nd of 2021. Now, as a defendant in a criminal case, you also have other rights. One other right that you have a right to have a trial by jury. And when those young ladies are sitting in that area, we call that area the jury box. 6 citizens will be selected to sit on your case, and they will decide whether or not you're guilty or innocent after listening to all the evidence. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, your case will come before the judge or the court in one of 2 ways. It can come before the court by way of what we call a bench trial. That's a trial before a judge only. Or it can come before the judge by way of a plea. A plea, if you have reached a plea bargain agreement to settle your case with the state, then we call that a plea bargain agreement. And then your case will come here. If you have reached an agreement with the state, we call that an agreed plea bargain. Now, if you and the state have not been able to reach an agreement and you still want your case, you still want to plead guilty or no contest, and you want your case to come before the court, then your case will come before the court by way of what we call an unagreed plea. Now, as a defendant in a criminal case, you also have a right to have witnesses to be called. In essence, what that means is You have a right to call witnesses in your case, and the witness, they sit in that chair right there to my left. We call that the witness stand. And what a witness do, they can testify either for you or against you. You can ask them questions, or your attorney can ask them questions if you are represented by an attorney. And we call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses, which means you have a right to not have witnesses to come and testify in your case. However, even though you will waive your right to have witnesses to testify in your case, the state will be calling witnesses to testify in your case. Now, you also have a right against self-incrimination. And what that simply means is you have a right not to say anything in your case. We call that, you may have heard it referred to as taking the fifth. What that means, you have a Fifth Amendment right against self-incrimination. And what that basically means, you have a right not to testify in your own case. And the state or the district attorney cannot force you to testify in your own case. Now, you also have a right to waive or give up your right to testify. And what that means is you have a right, if you say, well, I waive my Fifth Amendment right against self-incrimination and I desire to testify, then you will be testifying in your case. Now, you also have a right to have what is called discovery. Discovery is you have a right to see the evidence that the state of Texas has against you in your case. It could be by videos, documents, witness statements, etc. Now, you also have a right to waive or give up that right to discovery, which basically means that you don't want to see the evidence that the state has against you in your case. Now, earlier I mentioned the term plea bargain, and I also mentioned that you could enter a plea of guilty or no contest. Now, actually, you could enter one of three pleas in your case. You could enter a plea of not guilty. If you do so, you're telling the court that you did not commit the offense that you've been charged with, or you can enter a plea of guilty. And if you do so, you're telling the court that you committed the offense that you've been charged with, or you can enter a plea of no contest. And if you do so, you're telling the court that you will not be fighting, or you will not be contesting the charges that have been brought against you. Everyone here that's here for arraignment, you've been arrested on your case. Now, every day that you spent in jail on your case until you bonded out, that time can be used as credit towards your punishment. For example, let's say you and the state has reached a plea bargain agreement of 5 days in jail. And let's say you have already spent 5 days in jail or more. Then if you have, then you will be given credit for time served. In essence, you will not have to spend any more time in jail because you've already spent time in jail, the time in jail on this case. So therefore, you'll be given credit for time served. Now, if you have spent less time than what you agreed to, for example, if the state is offering you 5 days in jail and you was in jail 3 days, then that simply means you would have to serve 2 days in jail. Now, every day that you spent in jail, you get credit towards your fine and court costs at $100 per day. So if the state is offering you, you spent 5 days in jail and the state is offering you a fine and court cost of $500, that means that you won't have to pay any fine and court costs because the time you spent in jail has already paid it off. However, if you spent 3 days in jail and they offer you fine and court costs of $500, that simply means that you would have to pay $200. Now, if you cannot pay the $200 on the day of the sentencing, then the court can give you time to pay it off by allowing you to pay it off in installments or put you on what we call a payment plan. Now, if you cannot pay it off either by installments or payment plan, then the court can allow you, if you have been determined to be indigent, then the court can allow you to do community service to pay off your fine and court costs. Now, community service means that every hour of community service that you do, you will have $12.50 will go toward your fine and court costs. So if you do 8 hours of community service in one day, that's equivalent to $100 that will go toward your fine and your court costs. Jefferson County has a program that is, when I say Jefferson County, I'm talking about the district attorney's office, Judge Bob Wordham's office, has a program that is called pretrial diversion. And what pretrial diversion is a program for first-time offenders. And if you get into the program, your case is dismissed and you can get it expunged from your record. But expunged from your record means you can get it wiped off, deleted, or erased from your criminal record. The way it works is you have to qualify for the program. In order to qualify for the program, it has to be your first offense. You cannot have a criminal history. The next thing, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And then third, you have to have an attorney to assist you to get into the program. And if you get into the program, case is dismissed, you complete the program, you can get it expunged, which means erased, deleted, or wiped off from your criminal history. Jefferson County District Attorney's Office also has another program that is called Veterans Court. If you are a veteran of any one of the branches of the United States military, you may qualify for Veterans Court. And the Veterans Court is also a pretrial diversion program, which means that you get into the program, case dismissed, you can get it, once you complete it, you can get it expunged from your record. The only criteria is to be a veteran of any one of the branches of the United States military in order to get into that program. Now, this court, County Court at Law Number 2, has a program that is called the Community Safety Initiative. We normally refer to it as the CSI program. And that program is designed to address the issue of what we call recidivism. Recidivism means that people commit crimes over and over. And so how do we address the issue of recidivism? We address the issue of recidivism through a partnerships that we have with agencies and centers in our local community. The program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. Now, we have a partnership with Spindletop Center, used to be called Spindletop MHMR. Spindletop has, they're our local mental health center or agency. And if anybody have any issues, any mental health issues, we have someone in court who will be able to do private interviews from Spindletop. And Spindletop also can do an assessment, and they could develop a treatment plan, either outpatient or inpatient, for individuals who have mental health issues that needs to be addressed. Spindletop also has a program that is called ATAR. ATAR is a drug and alcohol recovery program. And the program ATAR stands for Addiction Treatment and Recovery. And that program is for individuals 21 years old or younger. And with that program, you can get an interview, get a screening, and they could develop a treatment plan, either outpatient or inpatient treatment for you as well. Now, Ozar, which is the local drug and alcohol counseling, they also have the ability to do a screening, interviews, and develop a treatment plan, either outpatient or inpatient as well, for individuals who are older than 21 years old. Now, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. And CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. That program is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once individuals are trained in one of those areas that they're interested in, hotel industry, shipping industry, and chemical industry, then they will assist you at getting employment in the area that you're trained in. If you have not finished high school and you do not have a GED, they have a GED program as well that can assist you to get your GED. Now, all of these programs that I have just mentioned are free. They do not cost you anything. Only thing you have to do is have a desire to be in one of the programs to address whatever needs that you have, whether it's mental health, whether it's alcohol, a drug addiction, whether it's unemployment, or you want to get a better job, or if you want to get a GED. All of these programs can be used to assist you in that area. The other thing about these programs that I've just mentioned, all of these programs can be used as community service. So for example, if you're required to do community service, and if you in the mental health program that Spindletop have, or the drug and alcohol program, or the GED program, or the job training, the job placement program, every hour that you spend in one of those programs, $12.50 will go toward your fine and court costs, and 1 hour is going toward your community service. So while you're being trained on a job, 1 hour is going toward your community service, and $12.50 is going toward your fine and court costs. So you're doing one thing, but you're getting credit for three things. I say that you're killing three birds with one stone. Now, as I said earlier, all of these programs are designed to address the issue of recidivism. And I tell people this all the time: when you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that come before this court. And we're trying to make a difference in the community in which we live. And we're trying to make a difference in Jefferson County by producing productive people. When you come to county court at law number 2, we do not just arrest the problem, we address the problem. And we do not just give time, but we take our time to make sure that we are able to produce productive people and address the issue of recidivism, because if we produce productive people, for the most part, do not commit crimes. And so if you're interested in any one of the programs, just let us know, and we'll be able to get you into one of the programs that you are interested in. Now, we have someone here from Spindletop, and she's going to come forward and tell you something about the program that they have at Spindletop.
Hey everybody, we do mental illness and substance abuse. I'll have a chance to talk to all of you today just for a second, just to give you a little card about our intake, in case you want to come in, or maybe you have a family member that you feel like needs to come in. Also give you the crisis hotline number. It's a good alternative to 911 if you ever feel unsafe and able to keep yourself safe, if you know, having suicidal, homicidal thoughts, things like that. They can talk you through things, point you in the right direction, and then we can help you with outpatient care after that. So if you have any questions, come find me, but I'm hopefully going to spend a second with each one of you while look at all your stuff.
Okay, thank you, Kennedy. Now, ladies and gentlemen, what we're going to do is we're going to have our staff to come and get the paperwork from you. It's going to take us a few minutes to go through the paperwork. And once we are able to get through the paperwork, we should be able to finish up what we need to do today. So just be a little patient with us. And now, if you need to go out and if you need to go out into the hallway, you can take a little break, but this is going to take us a little time to do what we need. So at this time, the court is going to be in recess.